Good afternoon, everyone. I am Charles Lita from Group 4, and for this session, I will be presenting our case analysis. Now, let's go on to our case background. So, to introduce, Mr. Roberto Cruz, an IT teacher, uploaded student multimedia projects to his personal YouTube channel without asking students or the school. Though his goal may have been to showcase talent and his proudness of his students, this led to privacy concerns, discomfort among students, and a complaint to IPOPHL and DepEd. His action was possibly violating the RA 8293, and this is where the problem arises. So, the IPR, or the intellectual property rights, are legal protections granted to individuals for their creative works, including inventions, literary and artistic creations like digital art, traditional art, written work, designs, and symbols, even, and logos. These rights give creators exclusive control over the use of their works, typically only for a limited time. So in the Philippines, IPR are governed by RA 8293, or the Intellectual Property Code of the Philippines. The Intellectual Property Office of the Philippines now is the one handling the cases like this. So, in the educational settings, IPR are crucial for recognizing and protecting the creative contributions not only of students, but of teachers and other third party artists and hired as well. So, as schools and education becomes increasingly dependent on technology and incorporating digital content into their curricula, it is essential for us that proper consent, ownership, and credit are upheld. So, when resolving an issue like this, we need to take a multi stakeholder approach. So, what does it mean? So, this means that the analysis should come from different lenses, from students to parents, from teachers, and school administrators. So, let's start. First, uphold intellectual property rights. So, Mr. Cruz should be required to delete all uploaded student content that did not have written content from students, and if they are minors, from their parents as well. This reinforces students' ownership of their own work and even parents' consent of their child. Second is mandatory written consent. So schools should implement policies requiring formal, signed consent before any student work is published online. So what we mean by online is not only on YouTube, but also on Facebook posts as well, and even Facebook stories, Instagram stories. Basta, all works published online should have written consent. Next is consent for continued publication. So if students want their work to remain online, there should be a clear agreement between the teacher, student, and parent with all terms documented in the written consent. So the IPR is not only established to provide or to limit the distribution of works, but because the IPR is established so that everyone or every person, every creative can flourish and can receive their due recognition. Next is policy and revision guidelines. The school's privacy policies must be updated to integrate the Data Privacy Act of 2012 and prohibit unauthorized posting of student content. So aside from the higher policies from DepEd, the schools should also, or SDOs, should provide a specific policy or guideline on the Data Privacy Act of students. Education and training. So, workshops for both students and teachers should be conducted regularly, focusing on digital ethics, netiquette, digital citizenship, consent, and intellectual property. So, this not only uh, helps the students be aware of their own rights, but also of the teachers as well. And for the case of Mr. Cruz, the teacher, him, must face appropriate consequences as stated in the as Code of Ethics or as the administrators see fit. This might include the cease and desist order and potential administrative administrative investigation. So, having said all that, what are the recommendations now? First, our first recommendation focuses on teachers. So, as teachers, as pre-service teachers, we must ensure that all educators are given regular training based on the RA 8293, not just during onboarding, but as part of continuing professional development. So, not only pre-service teacher, not only teachers studying for lead exam, but also in-service teachers. Teachers must understand that students are legal owners of their creative outputs and that uploading their work publicly without consent and formal consent is not just unethical, it is illegal. By encouraging informed consent practices, we protect both our student and our profession. Next, we address school administrators. So, as school administrators, they must lead the charge by crafting and enforcing updated school policies on intellectual property and digital publication. These policies must include clear consent procedures aligned with national laws like RA 8293 and the Data Privacy Act of 2012 and SIP swift administrative action in cases of violation. And now, for students and parents, awareness is key. So workshops or like campaigns, digital campaigns, community campaigns should be held to explain what intellectual property is. What's the difference between intellectual property and copyright? How can your work be copyrighted? Something like that. And why consent matters and how to protect personal and creative rights online where everyone can save and re-upload your work without consent. Parents should feel empowered to withhold or give consent, while students should understand that they have control and should have control over their own work and that sharing online carries risks. And then there's the Department of Education, so the DepEd must be at the forefront of this initiative. They can make digital ethics and IP laws part of mandatory teacher training, include modules on privacy rights and responsible content sharing, embodied intellectual property education into K to 12 curriculum, not only in senior high school, but also in junior high school and even in elementary education as well. By doing so, I think we can create a generation of educators and learners who understand their digital responsibilities and opportunities as well. And lastly, the Intellectual Property Office of the Philippines, or IPOPHL. I think they play really one of the major roles in this case. So we think and recommend that the IPOPHL should work closely with the Department of Education to first integrate IPR education into schools. So, as I've said, not only in senior high school subjects like media information literacy, but also in the basic education in elementary school and junior high school as well, and then should also provide resource materials for both educators and students. So, like the digital presence of IPOPHL may be appreciated in terms of digital campaigning for IP rights of students and teachers and even the general public. And lead public awareness campaigns not only online but also in person through programs and initiatives that is passed down in LGU and other NGOs if it's applicable. And we recognize that IPOPHL has already taken steps in this direction, but broader collaboration and implementation will be more appreciated. Once again, these are our references. I am Charles Lita. If you have some questions, throw it at me. And once again, this is for case analysis. Thank you so much for listening. Bye.